I hear a bill proposing significant changes to Scotland's criminal justice system, including scrapping the not proven verdict, will be debated by MSPs later. The Victims, Witnesses and Justice Reform Bill would also see pilots for judge-only trials in some rape cases. Kate Wallace is head of Victim Support Scotland.
Victims are overwhelmingly seeking the abolition of the not proven verdict, so we support that. In terms of the single judge trials, what's been proposed in the bill is a pilot and only for sexual offences, and we think that's really, really important because there's a lot of research that's demonstrated that juries really struggle with those sexual offence cases, that there is a lack of understanding about the directions that are given to the jury.
Well, let's speak to the KC, Thomas Ross. Good afternoon to you.
Hi, Hayley.
Interesting there that there is a view, first of all, just with regard to rape trials, that the juries essentially don't seem to understand the directions from a judge. Do you think it's difficult for a layperson to get their heads round?
I've got the most tremendous respect for our juries. I sat in a trial last week where a jury spent 3 days deliberating in a murder case involving a 20-year-old kid who they had never seen before. And I've got to be honest, it does annoy me when people come on and suggest that juries travel across Scotland every day by public transport to serve our justice system impassionately. And routinely, it's become normal for people to come into programmes like this and insult them by saying that they don't understand what they're doing, that they find things challenging. They do find them challenging, but they spend time coming back to the court and saying to the judge, I didn't understand that, can you explain it again? And it is explained again, and then they go away and they reach a proper decision.
And what do you think, how do you think as a legal professional that a case would be different in a judge-only trial?
Well, in the first place, because the government have come out and said that the purpose of the judge-only trial is to get more convictions. So that imperils...
I'm not sure I've actually heard a government minister ever say that.
The Justice Secretary, at the beginning of the process, made it very clear that the concern that the SNP have is that the conviction rate in rape cases isn't high enough. She said it yesterday in a statement to the Scottish Legal News that they're letting women down because she quoted a conviction rate of 24%. Now, that is wrong if none of those cases should have ended in a conviction. But if there was a reasonable doubt in the balance of cases, then there was nothing wrong about them at all. So if you start the process on the basis that every time somebody is acquitted, that there's a problem that has to be tackled, then it's clear the direction of travel.
Overall, the sort of remit of these changes, was to make the justice system better for victims, according to the government. Do you think there is a good intention behind this?
Absolutely, and I'm in agreement with a lot of the proposals. I don't have any objection to a victims commissioner, for example. I don't have any objection to the idea that there should be some training in relation to the lawyers to make them aware of the issues that are confronted. I'm in favour of all of that. But what I'm not in favour is somebody's 18-year-old son being thrown in the jail as a result of an unfair trial where a new judge has been put under pressure by the government to convict him. I'm not in favour of that, and I don't think anybody should be in favour of it.
And what do you think is the case at the moment? I mean, are you suggesting that judges would be lent on?
No, I'm not. What I'm worried about is a judge who finds himself or herself finding himself in the front page of the Sun because Rape Crisis are complaining that judge has acquitted 2 people this month, or that female judge has acquitted 3 people in 2024. That's what I'm worried about. Now, that's a natural pressure that anybody would feel in a finely balanced case. And it doesn't apply to jurors, because 15 jurors turn up. Nobody knows who they are. They reach a decision. We destroy the notes that they made. The law prohibits anybody from ever asking them what the basis of the decision was, and they disappear, and nobody can be criticised. It's different with a judge. Judges can come under pressure in the event that it's thought that judge is acquitting too many people. And that's a huge, huge psychological pressure when somebody is considering a finely balanced issue, such as whether to believe witness X or to believe witness Y.
There's also a proposal, of course, to reduce the size of juries from 15 to 12 and a requirement for a 2/3 majority for a guilty verdict. What do you make of that proposal?
I mean, I've never really understood it, to be honest. You know, we've shown that a jury of 15 works in Scotland. That happens every day in Scotland. I've never really understood it. I think the logic is if you have 12 people, then they're more likely to take part in the process. I don't really have a particularly strong view on it. I think it's completely wrong that we're probably the only country with a jury system where you can get a life sentence for murder on the basis of an 8-7 majority. And there was a proposal that if we went to 12, there would be a need for 8 people to vote for a conviction, and that made perfect sense to me. It brought it into line to some extent with the English system. But I'm not sure the committee were convinced about that, and I think we're back to a situation where if the process is unchecked, we'll only have 2 verdicts, but you could be convicted of murder on 8-7 majority, and that clearly is wrong.
OK, Thomas Ross, thanks very much indeed for joining us. That's the defence lawyer Thomas Ross KC, talking about those changes to the justice system on the day that MSPs start debating the proposals.